morning, Josh. How are you?
I am super. How are you?
Now we're cooking.
Good morning, Mr.
Josh.
Hadley.
Good morning, everyone. Hey, Sona.
Good morning.
I hear Judge Martin.
I'm here. I'm just
Yep.
trying to get situated before I
Hey.
turn the
No worries.
video around. Ugh.
Josh, you want to go into a breakout
Yeah,
room? and we can go-
let's do that real quick. Because I've got two of them that I think we may have resolution. I just want to talk to you real quick.
Wonderful. I will move you. Give me 1 second.
Ma'am that just joined us in the black jacket, what is your name, please? Oh, no, so close.
Hi, can you hear me?
I can hear you now, ma'am. Your name, please?
My name is Taylor Desgrange. Nice to meet you.
Good to meet you. What are you here for, ma'am? The
I am
910
here-
docket?
I believe that's what it's called, the domestic violence second offense.
Yes, ma'am. Okay. The prosecutor and court-appointed attorney are here. If you sit tight, we'll get to you here momentarily, okay?
Awesome, thank you.
You're welcome. Good morning, Mr. Kaplan.
Good morning, Your Honor.
How are you, sir?
I'm doing wonderful. How are you?
I'm well, thank you.
I'm here for Joshua Hines. She's an in-custody case. So.
I see that Ms. Moisizian is here.
It was set for a final pretrial for the victim to appear. So I don't know if we have a victim appearing or not today.
I have not seen that victim as of yet. My cutoff time is about 15 minutes after the scheduled time.
Yep, I figured.
Ms. Dennis is here. Ms. Dennis, I'm not sure if you've had any contact with Erica Radford.
No, I have not, but I could try to give her a call now. Again. Hold on.
Krishna Das,
Yes, sir. Yes, ma'am.
how are you this morning?
I've been better.
What are you here for?
Court had at 9:15. I think I was supposed to log at 9:10 with my attorney from Bogart Laws.
Thank you. I have not seen your attorney as of yet.
My name's Timothy Shepard. Christian.
I figured based on the attorney's name. It's okay.
Yeah.
We haven't seen Mr. Bogart just yet, but if you sit tight, we'll get to you as soon as we possibly can, okay?
All right. Thank you.
You're
Ma'am.
welcome. Thank you. Were you and Mr. Hadley ready with something?
I believe we are, as soon as we have either Taylor DeGrange or Gabriel Stevens present.
Oh, yeah, I'm here.
All right. Mr. Stevens, I apologize, actually, Your Honor. I need to speak with Mr. Stevens really briefly.
Absolutely. Good morning, Mr. Mijas.
Good morning. How are you?
I am wonderful. How are you?
I'm good. I'm here with Mr. McLaughlin.
I was going to ask, was he with you? Great. Do you need to speak to the prosecutor?
It's just a pretrial. We can go ahead.
Is this on the, you said McLaughlin, right?
McLaughlin.
Yes.
Yes, okay.
If you're ready, this is 220264 SM, State of Michigan versus Martin McLaughlin.
Yes,
Your
good morning.
appearances, please.
Sorry, Your Honor. Good morning. Sonam Mosisian on behalf of the people, P83923.
Good morning, Your Honor. Harry Mihas on behalf of Mr. McLaughlin, P number 66417. Can you state your name?
Martin Patrick McLaughlin.
Thank you. Thank you.
Thank you. Today is the day and time set for the final pretrial in this matter. How are we proceeding this morning?
Yes, Judge. I did have an opportunity to speak with the complainant in this case, Kristen Townsend, and given her statements to me, the people are unable to proceed without her, and therefore, because she no longer wishes to cooperate, so we're not going to be able to proceed.
Your Honor,
Motion, sir.
I'd ask for a dismissal, Your Honor.
Defense motion to dismiss, it's granted. Anything else on behalf of the people?
No, that's it. Thank you.
Anything else on behalf of the defendant?
That's all, Your Honor. Thank you.
Thank you. Have a good day. Good luck to you, sir.
You too.
Thank you. Good morning, Mr. Bogart.
Good morning, Your Honor.
Do you need to speak to your client, sir?
I do not, Your Honor. Could I have a moment with the prosecutor?
Yes.
Absolutely.
Thank you.
Excuse me, Your Honor, I just spoke with the victim, but when Sonia gets done, I'll talk to Sonia about it.
Thank you, ma'am.
Okay. Your Honor, which case was that we just did that was dismissed?
That would have been McLaughlin from the 9 o'clock docket, Martin McLaughlin, 220264.
I was talking to the victim. I couldn't hear.
Understood.
Okay, thanks.
Mhm. Mr. Hadley, when the prosecutor comes back, there's one case ahead of yours, and then we can go forward with Ms. Desgrange and Stevens.
Very good, Your Honor. Thank you.
Oh. Your interns get younger and younger, Mr. Hadley.
You know, the interns are in the office today. Royce brought both of them in. Some just different flavor.
Thank you, ma'am. This is 220450 SM. This is State of Michigan versus Joshua Hines.
Good morning, Your Honor. Sona Movsisian on behalf of the people.
Good morning, Your Honor. Joshua Kaplan on behalf of Mr. Hines.
Today was the day and time set for the final pretrial in this matter. It was scheduled at 9 o'clock. It's now 9:19 by the court's clock. I know that Ms. Dennis made an effort to reach out to the victim in this case. How are we proceeding this morning?
Judge, is the defendant here?
The defendant's in custody with MDOC, and we've had some, it appears, communication issues getting him here.
Okay.
Unless
Yeah,
Mr. Kaplan has some more recent information.
I do not. Last I knew, he was still in custody. He was supposed to be in custody for a year, Your Honor. So he's not getting out anytime soon.
That is correct. I believe that was what was shared with me as well in the past. My only concern here is this case is back from June, and part of it was because we couldn't get a hold of the defendant. I think I have at least 4. And during those times, I very much had a lot of communication with the complainant. I had communication with the complainant since October, or prior to October. So my only concern is yesterday I was not able to reach her. And so I would be hesitant to have the case dismissed only because of the fact that she was very cooperative. And part of it was that it was taking so long to get the defendant to these hearings. And so my request would be to have one more final pretrial, just because of the amount of time that's gone by. I don't want this case to get dismissed solely because I wasn't able to reach her.
I was able to speak with her this morning. I wanted to speak with you in a breakout room.
Oh, you were?
Yes.
Oh, wonderful. Okay, thank you.
Well, don't go into the breakout room just yet.
Yeah.
Mr. Kaplan, if you could sit tight, let me get rid of a few more things.
Yeah,
This
Your
is
Honor.
220711 SM, State of Michigan versus Timothy Shepard.
Ready, Your Honor.
Good morning, Your Honor. Sonam of CCN on behalf of the people, P83923.
And good morning, Your Honor. David Bogart appearing on behalf of Mr. Shepard, who appears via Zoom. He consents to appearing via Zoom and waives his physical appearance. My P number is P74745. Mr. Shepard, please tell the court your full name.
My name's Timothy Michael Shepard.
Thank you. Today is the day and time set for the pretrial in this matter. Mr. Bogart, how are we proceeding this morning?
Your Honor, I've had a conversation with Ms. Moivisian and I've also talked to my client. We'd ask for a final pretrial on this matter before setting it. There is some body cam that the prosecutor has indicated that she would be able to get to me. We just want to review that, and then we believe that we may even proceed to a resolution, Your Honor.
That final pretrial date will be
November 22nd at 9:20 with Judge Green.
November 22nd.
final pretrial by Zoom on November 22nd at 9:20 a.m. That's courtroom number 3. Anything else on behalf of the people?
No, that's it. Thank you.
Your Honor.
Anything else, Mr. Bogart?
Yes, Your Honor. I have a hearing at 8:45 in the Westland Court. Is there any way we could put that a few minutes later?
The latest that is available is 9:40.
9:40 is better. That'll work.
9:40. We'll see you on November 22nd. Mr. Shepard, have a good afternoon, sir. Good luck to you.
Yes, you too, man.
Thank you, Your Honor. And that's by Zoom or in person?
That's by Zoom, sir.
Thank you. Thank you very much, Judge.
No worries. Have a good day.
Thank you. You and your staff have a good day as well.
Thank you. This is 220713 SM. This is State of Michigan versus Taylor Desgrange. May I have your appearances, please?
Good morning, Your Honor. Sonam Movsisian on behalf of the people.
Good morning, Your Honor. Attorney Josh Hadley appearing on behalf of the defendant, Ms. Taylor Desgrange. She's appearing via Zoom and waives her right to be present in court today.
Ma'am, state your name for the record, please.
Your Honor, my name is Taylor Desgrange.
Thank you. Today is the day and time set for the pretrial on this matter. Mr. Hadley, how are we proceeding?
Your Honor, after discussion with Ms. Moivisian, I believe the people will be dismissing the case without prejudice at this time.
Judge, that is correct. I spoke with the complainant. He no longer wishes to proceed, and therefore we are unable to do so without his cooperation.
Your motion, Mr. Hadley.
Your Honor, we have a motion that the matter be dismissed.
Defense motion to dismiss is granted. Anything else on behalf of the people?
No, that's it. Thank you.
Anything else on behalf of the defendant?
No, Your Honor.
Ma'am, good luck to you. Have a good day. You're free to leave.
Thank you for your. Bye-bye.
Have a good
Bye-bye.
day.
This is 220705 SM. This is State of Michigan versus Gabriel Stevens. May I have your appearances, please?
Good morning, Your Honor. Sonam Movsisian on behalf of the people.
Good morning, Your Honor. Attorney Josh Hadley appearing on behalf of the defendant, Mr. Gabriel Stevens. Mr. Stevens will be appearing via Zoom, waives his right to be present in court today.
Mr. Stevens, state your name for the record, sir.
Gabriel Stevens.
Thank you. Today is the day and time set for the pretrial in this matter. Mr. Hadley, how are we proceeding?
Your Honor, after discussion with my client, we would like to avail ourselves of the people's offer whereby Mr. Stevens will be pleading guilty to domestic violence first offense under 769.4A. I believe it'll be a period of 12 months probation. Is that correct?
Yes, and Mr. Hadley, my apologies. I just sent you a message, but it would include the 12 months probation, batterers counseling, no assaultive contact, and then the people would request also parenting classes. And then I did not speak with Mr. Hadley about that. That was my bad. And so if it's something that you need to discuss with your client, or if you have any objections, we can leave it to the determination of the judge.
I did advise Mr. Stevens that the batterers counseling, some type of anger management would be most likely accompanying this case. He understood that and agreed to as such. Mr. Stevens, do you have any issue with the parenting class that the prosecutor just mentioned?
No.
Okay. No, Your Honor, with everything being said, we understand the totality of the plea offer and we would like to avail ourselves of said plea.
Thank you. Mr. Stevens, raise your right hand for me, sir. Do you swear a firm testimony you give in this matter will be the truth, the whole truth, and nothing but the truth?
Nothing but the truth.
Thank you. Sir, you put your hand down. Sir, you understand that if the court accepts your plea this morning, you will not have a trial of any kind?
Yes.
You will not have the opportunity to present witnesses on your own behalf or see and cross-examine witnesses put forth by the prosecutor.
Okay.
And sir, you're entering this plea freely and voluntarily?
Yes.
You haven't been threatened in any way, promised anything to get you to plead guilty?
No.
Are you pleading guilty because you are in fact guilty?
No.
No, you're not guilty?
No, I didn't.
Mr. Stevens, the judge is asking you if the date in question, did you physically put your hands on the victim without permission to do so?
No, I didn't mean to.
Mr.
Okay, but-
Hadley, do you want to go back into a breakout with Mr. Stevens momentarily?
I think that's a good idea, Your Honor.
Thank you. And Ms. Moisezian will go in with Ms. Dennis so that we can get Mr. Kaplan's case recalled. Mr.
Yes.
Scanlon, I see you. We'll get to you momentarily, sir.
Thank you, Your Honor.
To the gentleman with the glasses and the gray hoodie, your name, please.
Virgil Smith.
Thank you, Mr. Smith. Mr. Scanlon, is your client with you or is he joining us?
Your Honor, I've been texting him and calling him all morning, and I'm not able to reach him.
Okay,
I know that we had the bench trial scheduled, the in-person bench trial for 11 o'clock. I'm hoping and praying that he's not going to show up there at 11.
I'll be here because I have a docket that's still going on at that time. So if he shows up at 11, we'll see what happens. But
I mean, I guess I could zoom in at 11. I sent him a text and I've called him multiple times to say, we're live right now. He might still be thinking that we still have that bench trial scheduled for 11.
Mr. Zaia, do you need to speak to Mr. Smith?
No, Your Honor, this is a motion to set aside conviction. We're prepared to proceed.
We're not quite ready yet. There's a few other things the prosecutor needs to tend to, but we'll get to you momentarily.
Okay, thanks.
You're welcome.
Why is he going to daycare?
Please mute yourself, sir.
Pardon me?
I said, please mute yourself.
Oh, okay.
Let me get Mr. Kaplan out of here first.
Judge, may I,
20450 SM, I'm sorry.
can I just have a second with Mr. Kaplan, please?
Absolutely, ma'am.
Thank you. Thank you, Judge. We're ready.
Thank you. Back on the record in 220450 SM, State of Michigan versus Hines. I have your appearances. Ms. Moisizian, how are we proceeding?
Yes, Judge. I was informed by our victim advocate that we made contact with the complainant and she's not present today because she is at work. She's unable to take the time off that she needs to come to these court proceedings. And unfortunately, given the fact of how long it's taken, it's something that she just cannot do with her work schedule as well as being a single parent. And so I was trying to see if we could do some sort of agreement with like an anger management course through the current placement that Mr. Hines is in. However, that doesn't sound like that's going to be possible. And so with that, we are not able to proceed today.
And Your Honor, I would make a motion to dismiss on those grounds. I would also add, just for the record, that my client is going to be incarcerated for, I believe, another 8 or 9 months before release.
Thank you. Mr. Kaplan, the notes in this court's file indicates that his earliest possible release date is June of 23.
Yeah.
The court will grant the defendant's motion to dismiss. Anything else on behalf of the people?
No, thank you.
Anything else on behalf of the defendant?
No, Your Honor, thank you.
Thank you for your patience this morning, Mr. Kaplan. Have a good day, sir.
Always a pleasure. Thank you, Your Honor.
Thank you. Back on the record in 220705 SM, Mr. Stevens, my question to you was, are you pleading guilty in this case because you are in fact guilty?
Yes, I'm pleading guilty.
Thank you. Mr. Stevens, is it true that on October 13, 2022 at Detroit Metro Airport, which is located city of Romulus, County of Wayne, State of Michigan, that you did make an assault or an assaulted battery upon Melonia Tucker, an individual with whom you had a child in common and or an individual with whom you had a dating relationship?
Yes.
Mr. Hadley, would you like to inquire further of your client?
No, Your Honor, we feel the elements have been satisfied.
Satisfied, Ms. Moisizian?
Yes, Judge.
And is Ms. Tucker here this morning?
She is not.
Do we need to continue this matter to allow her to come in and make a victim impact statement of any kind?
No, I do not believe so. I spoke with her. That's not necessary.
Thank you. Mr. Stevens, your plea of guilty to the sole count of domestic violence is taken pursuant to MCL 769.4A. As indicated previously, there will be a 12-month probation period in this matter. You are to have no assaultive contact with the complainant in this case, that being Melonia Tucker. You are to engage in parenting classes, anger management classes, follow the directions of the probation department. You will be assessed a fine. Fines and costs that, as are required by statute in this matter. The probation department will use the information that you verify, your phone number and email address, to be in communication with you about the expectations and requirements upon you.
Okay.
You will be responsible for the costs associated with your counseling program, sir.
Okay.
court's assessing the fine of $100, I'm sorry, $500, cost of $100, a $75 crime victims fee, $50 state cost, $20 fund fee, the oversight fees, and again, the cost of any of the other requirements that the probation department feels are necessary in this matter. Anything else, Ms. Moisezian?
Judge, I just want to confirm, did you say no assaultive contact?
I did.
Okay, wonderful. Thank you.
Anything else, Mr. Hadley?
No, Your Honor.
Thank you. Mr. Stevens, good luck to you, sir. The probation department will be in touch with you.
Okay.
Good luck,
Thank
Mr.
you.
Stevens.
These are 091554 SM and 101647 SM. These are both state of Michigan versus Virgil Joseph Smith III. May I have your appearances, please?
Good morning, Your Honor. Justin Zaid appearing on behalf of Mr. Smith, who is present and consents to appear via Zoom. Mr. Smith, can you unmute yourself and state your full name?
Virgil Smith III.
Thank you. Today is the day and time set for hearing on the defendant's motions to set aside prior convictions. It's your motion, sir. Please proceed.
Thank you, Your Honor. As you indicated, this is Mr. Smith's application to set aside a conviction in this court. Your Honor, as a threshold matter, Mr. Smith meets all statutory requirements under 780-621. It's been well over 5 years since this incident. This underlying conviction is eligible for expungement. We have submitted to the court for the court's edification the letter from the Attorney General, as well
I'm
as the
sorry,
MSP
Mr. Smith, are
records,
you
both
driving or are you the
indicating that
passenger?
Mr. Smith.
No, I'm not driving.
I'm sorry to interrupt you, sir. I just want to make sure I have your client's attention during his hearing.
Yes, I'm not driving. I'm a passenger.
Understood, Your Honor. May I continue?
Yes, please pick up from, you have the Attorney General's letter in the file.
Understood, Your Honor. So we have the Attorney General's letter, the MSP records, both of course indicating that Mr. Smith is eligible. Now, more importantly, Your Honor, since this incident over almost 13 years ago, Mr. Smith has completely transformed his life. He just recently got remarried about a month ago, and he has 3 children, one of which is still living in his home. And he, of course, financially supports and is help raising. Even more than that, Your Honor, he is also a small business owner. He's an entrepreneur. He's employing members of his own community. He runs a tattoo parlor which he's owned for the last 20 years. He's got 6 people under his employ. In addition to that, Your Honor, he's also involved in his community with the youth. He runs a workshop every weekend at his tattoo shop. It's a volunteer program where he teaches them young aspiring artists, as well as coordinating with parents in the local public schools to help students who are inspired and ambitious to get into the art industry. Your Honor, as I indicated, Mr. Smith has not reoffended whatsoever. He's transformed his life. As I may have mentioned before, he also had another matter in circuit court. We already got that one expunged. And this is the last impediment in his way of having a completely clean record. And he has full intent and motivation to keep it that way moving forward, if Your Honor is to grant this application.
Thank you, sir. Anything from the people?
Yes, Judge, thank you. So I also was able to go through our office's requirements to make sure that he is eligible. And everything that was stated in regards to his background check is correct. He has no additional convictions that would disqualify him. The only thing that I was unable to do, despite my efforts, was get in touch with the complainant. Usually we have to notify the complainant. In this case, there were 2 incidents from 2009 and 2010 that led to the convictions with the same complainant, Andrea Smith. The phone number that we had on file is no longer valid. I did request that the police department look into any updated contact information from her. They do not have anything as of recent. And so besides being able to at least notify her, we have no other objections to the expungement.
Thank you, ma'am. Inasmuch as it appears that this application has been pending for quite some time, Mr. Smith has appeared timely and appropriately this morning. Mr. Zayed has made a wonderful argument on his behalf. The court will grant the application. Mr. Zayed, if your office would be so kind as to submit orders in both of these matters, would be most appreciated.
Will do, Your Honor. Thank you very much, and you have a great day.
You too. Mr. Smith, good luck to you, sir. Have a good day.
Thank you.
I am in.
Mr. Goisich?
Gotcha.
Gotcha. Thank you. This is 220369 SM, State of Michigan versus Gacho.
Good morning, Your Honor. Sonam Susan on behalf of the people. Mr. Scanlon, I think you're muted.
Morning, Your Honor. May it please the most honorable court, Gerard Scanlon, P number 74992, appearing on behalf of Mr. Daniel Gaucho, who is present via Zoom. Will waive formal appearance in the court, but wish to appear via Zoom technology.
Thank you. And your client has already stated his name for the record. This case was actually scheduled for a live bench trial this morning at 11 o'clock. This court received communication yesterday that indicated that there would be a different resolution. Mr. Scanlon, how are we proceeding this morning?
Your Honor, the prosecutor has offered to permit my client to avail himself of a plea of guilty to the charge of domestic violence. That plea will be taken pursuant to 769-4A. And my client has indicated to me, after a thorough discussion of all the risks regarding this plea, that he'd like to avail himself under that plea.
Thank you. Sir, would you raise your right hand for me, please? Do you swear or affirm the testimony you give in this matter will be the truth, the whole truth, and nothing but the truth?
You.
Thank you, sir. You may put your hand down. Sir, you understand that the court accepts your plea of guilty this morning to the sole count of domestic violence. You will not have a trial of any kind?
I do.
You understand that you will not have the opportunity to present witnesses on your own behalf or see and cross-examine witnesses put forth by the prosecutor?
I do.
And sir, you're entering this plea freely and voluntarily?
I am.
You have not been threatened in any way, promised anything to get you to plead guilty?
No, I have not.
Are you pleading guilty, sir, because you are in fact guilty?
I don't believe I am, but this is the best and cheapest outcome for me. So that's basically it.
Let me ask the question again, sir. Are you pleading guilty because you are in fact guilty?
Yes.
Sir, is it true that on May 18, 2022 in Huron Township, which is County of Wayne, State of Michigan, that you did make an assault or an assault and battery upon Sheila Gaucho, your spouse?
I didn't touch her. I don't know if that's assault.
Mr. Scanlon, would you like the opportunity to speak to your client?
Yes, I would, Your Honor.
Mary Ann, let's get them moved into a breakout room, please. Good morning, Mr. Blake.
Good morning, Judge. Great to see
How are
you.
you, sir?
Fine. How about yourself?
I am super. Is your client with you or are you expecting her separately?
Separately, Judge.
We have one unidentified person on the iPhone. We'll find out who this is.
Tina Taylor.
That's her.
Ms. Taylor, turn your video on for me, please. Do you
Turn
need to
it on.
speak to your client or are you ready to proceed, sir?
We're prepared and ready to proceed, Judge.
This is 220705 SM. This is State of Michigan versus Gabriel Terry Stevens. I'm sorry. Let's try it again. This is 220501 SM. That feels a lot better. This is State of Michigan versus Sheena Taylor.
Good morning, Your Honor.
Appearances, please.
Sorry, Sonam Obsesian on behalf of the people.
Good morning again, Your Honor. Wright Blake appearing on behalf of Sheena Taylor, who's on Zoom per our consent.
Taylor, state your name for the record, please.
Tina Taylor.
Thank you. This case was scheduled for a live bench trial today. The court received communication that there would be a different resolution. Mr. Blake, how are we proceeding this morning?
Your Honor, my client is prepared to enter a no contest plea pursuant to 769.4A.
No contest? The basis for the no contest plea?
Civil liability, Your Honor. And I believe the prosecutor is in agreement with that.
Judge, no, I wasn't necessarily in agreement. We just didn't have an objection to it. It's up to the discretion of the court if you would like to accept that.
You take no position, ma'am?
On this specific one, that is correct.
I will leave it alone. Ms. Taylor, raise your right hand for me, please. Do you swear or affirm the testimony you give in this matter will be the truth, the whole truth, and nothing but the truth?
Yes.
Thank you. You may put your hand down. You understand that if the court accepts a plea from you this morning, you will not have a trial of any kind?
Yes.
You will not have the opportunity to present witnesses on your own behalf or see and cross-examine witnesses put forth by the prosecutor?
Yes.
And you're entering this plea freely and voluntarily?
Yes.
You haven't been threatened in any way, promised anything to get you into the no contest plea this morning?
No, ma'am.
Inasmuch as this is a no contest plea, the court just wants to read into the record that there was an offense date of July 5th, 2022, where it's alleged that at Detroit Metro Airport, which is located city of Romulus County, Wayne, state of Michigan, that you did make an assault or assault and battery against AUISHA White, an individual with whom you had a dating relationship. Based on the fact that, again, that there's a no contest plea, Mr. Blake, do you have any objection to the court relying on the police report for the additional factual basis for the complaint?
No, Your Honor.
And Ms. Taylor, it's your understanding and agreement that this will be a plea subject to MCL 769.4A?
Yes.
And that is how you wish to resolve this matter this morning?
Yeah.
Are the people satisfied?
Yes, Judge, thank you.
Mr. Blake, are you satisfied?
Satisfied, Your Honor.
The court accepts the no contest plea in this matter pursuant to MCL 769.4A. Does this matter need to be continued to allow the victim to appear to make any victim impact statement, or are you ready to proceed this morning? Ms.
No.
Susan?
Judge, we are ready to proceed this morning.
And likewise, Judge.
Thank you. As provided by statute, Ms. Taylor will be placed on 12 months of probation. The court will impose a fine of $500, cost of $100, crime victims fee of $75, state cost of $50, fund fee of $20. Ms. Taylor will also be responsible for any oversight fees to the probation department. Will engage in anger management classes. Have no assaultive contact with the complainant. And follow all other directions of the probation department. The probation department, Ms. Taylor, will use your previously provided phone number and email address to be in communication with you as is necessary. Anything else in this matter on behalf of the people?
No, Judge, thank you.
Anything else on behalf of the defendant?
No, Your Honor.
Thank you. Ms. Taylor, good luck to you, ma'am. The probation department will be in contact with you.
Thank you, Your Honor. Have a marvelous holiday.
Thank
You
you.
too, sir. Thank you. This is a recall of 220369 SM. Court has your appearances. Mr. Scanlon, have you had sufficient opportunity to speak to your client?
Yes, I have, Your Honor.
And how are we proceeding?
We're going to proceed with the plea, Your Honor.
Mr. Gaucho, the court's question to you was that, is it true that on May 18, 2022, in Huron Township, that you committed an assault or assault and battery upon Sheila Gaucho, your spouse?
Yes.
Are the people satisfied?
Yes, Judge, thank you.
Mr. Scanlon satisfied?
Satisfied, Your Honor.
Thank you. Mr. Gaucho, this plea has been taken pursuant to MCL 769.4A. Was there any discussion and agreement between the parties for any anger management or period of probation?
Yes, Judge, it would be the standard that we usually have, 12 months probation, batterers counseling, and no contact with the complainant who is
No
present.
contact or no assault of contact?
No contact.
Okay.
I think any contact that they have is going through their attorneys through the divorce proceedings.
Okay. Mr. Scanlon, anything you'd like to say on behalf of your client?
This was an unfortunate event, Your Honor, and my client regrets this. And I want to point out to the court that he's very contrite, he's very humble. I've had an opportunity to speak with him over the past, I would say, 6 months of representation. And he was very apologetic for the situation. It was a big misunderstanding, and he wanted to apologize.
Thank you, and it is appreciated. Mr. Gaucho has appeared with this court multiple times and has always been timely, appropriate, and contrite. Court will impose the standard sentence in this matter, that being 12 months of probation. No contact with the complainant in this case. Mr. Gaucho, I heard your attorney indicate that all contact is through the attorneys, but sir, no contact means no contact, no direct contact, no contact to third persons, no contact through social media. You will engage in batterers counseling and any other requirements that the probation department feels are necessary in this matter. Court will impose the fine of $500, cost of $100, all oversight fees, $75 crime victims, $50 mandatory state costs, $20 fund fee. The probation department will be in contact with you at the phone number and email address that you've previously provided. Anything else on behalf of the people?
No, Judge. I don't know. I don't think the complainant wants to say anything. I just want to make sure that we ask her just to confirm that.
I can see her. Ms. Gaucho,
Yes, Your Honor.
anything you'd like to say in this matter?
No, Your Honor. Thank you.
Thank you, ma'am. Thank you for your patience this morning. Good luck to you, Mr. Gaucho.
Thank you, Your Honor. Have a great day.
You too, sir. Thank you. That was,
I think that is all.
that is it for this docket. I have a civil docket coming. Ms. Movsesian, I'll see you tomorrow, I believe.
Yes, actually, my colleague / supervisor is going to be stepping in for me because I am scheduled for a jury trial, so I will not be there.
No, there are no jury trials, no. Thank you. I'll see you
But I
maybe
will
next.
They're trying to place me in so many different courts, so I'm just trying to juggle it all.
Maybe next week on our felony docket.
Thank you so much. I'll talk to you later.
I'll see
Thank
you
you.
tomorrow, Your Honor.
Thank you, Ms.
On the
Dennis. I'll
state
see
docket.
you.
Thank you. You all have a great one. Stay warm.
Yes, ma'am. Mr. Hadley. Thank you, sir.
Absolutely. Good to see you, Your Honor. Have a great day.
No worries.
Thank you.
Ms. Harris and Mr. Marks.
Good morning, Your Honor.
Good morning.
I'm sorry, give me 1 second.
No, no, take your second. I need the briefest of recesses. I'm going to take these files to my secretary. I'll be back in less than 5 minutes.
Oh, okay.
Thank you.
Mr. Marks, do you need a breakout room? I made you co-host. I don't know if you need to go in a room with her.
I don't think so at this point, unless Ms. Harris needs to say something to me. I don't think so. This is just a hearing on their motion at this point. So,
Okay, thank you.
thank you.
Mr. Marks and Ms. Harris. I heard Mary Ann ask if you needed to speak, and I think the answer was no. So the court is prepared. These are 223390LT and 223388LT. Park Estates versus Arnold Harris and Victoria Harris, and Park Estates versus Laura Singleton and Carl Singleton. May I have your appearances, please?
Jeremy Marks appearing on behalf of the plaintiff.
And Your Honor, Tabitha Harris appearing on behalf of the defendants. And Your Honor, I would ask if the defendants in these matters, if their presence could be waived for this hearing.
Any objection, Mr. Marks?
No.
I don't think that they're necessary for these proceedings. These motions were received in my absence, and so they are combined. There's two sets of these motions, and they all have a single caption for multiple cases. I am not a fan of that because I don't think that the specific facts are transferable, for lack of a better word, in both cases, and the exhibits are a singular lease versus the specifics of the tenants. That's an aside more than anything else, but Ms. Harris, this is your motion, ma'am.
Yes, Your Honor, and I apologize. I kind of put them together because I know that they are different. There are different facts as far as our overall case, Your Honor. But as far as of conducting business electronically, that's why I put them together. And we did tell the, I think we did speak to the clerk, and she had indicated if you didn't want it that way, we would have changed it, Your Honor. So I apologize for that.
That somebody else made that decision in my absence. I'm saying it out loud in case there are future motions in this fashion. I'm just not a fan of them because I don't know that the Harrises and the Singletons are similarly situated. But that, again, that's more an aside than anything else. I'll let you proceed with your motion, Ms. Harris.
Thank you, Your Honor. So I did bring this motion, Your Honor, because one of the issues that both the Harrises and the Singletons have had is that the Park Estates, when it was taken over by Vineyards recently. At first, there was no issue. They did offer some electronic means of payment. Then they had a community manager there until March. So both Singletons and my parents, the Harrises, they would pay with a money order. They would take it to the community office. So after there was no community manager and there was no way to really get a hold of anybody from Vineyards management, that's when I think things started going awry. And they did offer the pay lease. And I just want to, say, Your Honor, that that's another issue here with the Harrises and the Singletons, is that they pay by pay lease. And I am going to be providing that information. My computer scanner is on the fritz, so I'm trying to juggle that. But at any rate, Your Honor, the electronic payments, nobody knows where they're at. They're going to, have to kind of figure this out. And this is why we're actually in court, because they've been saying that they haven't paid when actually there have been payments. And basically, Your Honor, what I'm saying and what I've been telling them all along and saying is that, even if plaintiffs are arguing that the E-Sign Act doesn't apply because it's federal, Your Honor, we just, really that's the only thing we really have to look to as to how electronic business should be transacted. And when we look at most of the business industries, and as far as mostly every industry in business, people have to consent to doing electronic transactions. And here, Your Honor, they've taken that away. They've not gotten, the consent. And especially with, a lease, and I do want to make it clear, Your Honor, I'm not asking them to provide a paper lease to each and every resident. That wasn't what I was asking. What I'm saying is that per the Michigan statute, it's clear that the parties have to agree. And that's what the statute regulates, is if there's an agreement between the parties. And my reading of the statute is that if the parties don't agree, then there's going to be a problem with the legality of any type of electronic signatures. And so, Your Honor, I'm asking specifically, as far as the defendants that I have, they are senior citizens. They are not able. I know Ms. Singleton is even having a computer. She has like a basic mobile phone. It is a smartphone, but it's not an advanced smartphone. My parents do have a computer, but they need help to operate that, operate the computer and, to do these things. And I know, Your Honor, as an attorney, I have a good cell phone, however, for something as important as a lease, anything important, I always want to look at it in paper form. So I don't understand why it's a problem for them to provide, if the residents have asked that they receive things in paper form. I don't understand why it's a problem, for them to, abide by this. I don't see why there's a problem, why they're forcing them to do things electronically. The other thing is with the payments, Your Honor, clearly the electronic payments are there's issues there. People have had issues with the portal. Then, the same thing with pay lease. So I don't even understand why it's a problem for having a Dropbox. The Dropbox is inside of the community center. And I know that plaintiffs did say that, I was kind of generalizing and saying that seniors and, low income people are being discriminated against. However, it is also a generalization on plaintiff's part to say that the Dropbox is, that there's going to be missing payments and things like that, because, there's been no evidence that there's been any issues here, and the Dropbox is inside of the building. So, Your Honor, I that's, what we're asking is that, these are important legal documents, and it is causing a, big problem, which is why we're even here. And we even have these cases before you, why there's even an eviction, especially in the Singletons and the Harris's case. The other issue is that they've been charging fees. So they've asked them to sign a lease. They won't provide the lease in writing. They're telling them if they don't do it electronically, that it's not a lease. And so therefore they've got to pay an extra $100. It's also causing extra late fees that are on, their account, even though they have paid through the pay lease. And, now we're doing the escrow with the court, and that, that's taking care of that. But Your Honor, it's still not a, electronic means is not a catch-all. And I do believe that there's nothing that, as far as the Michigan statute, that there's nothing that says that people have to conduct business electronically. I think, Your Honor, in 100 years, maybe this, won't be an issue because maybe nobody will be using paper. But as of now, Your Honor, we do have people that are not situated. I'm so sorry, Your Honor, we don't have people that are similarly situated. We don't have people that are adept in this. And I just think that it's, it's unfair, Your Honor. It's wholly unfair. I think that one of the things that the e-Sign Act as well as the Michigan Act both agree on, that in order for electronic transactions to be, to be legitimate, there has to be an agreement between both parties. If there's not an agreement, then the validity of these electronic signatures could be questioned. So, Your Honor, I just, I don't see where the problem is. The problems did start, honestly, when all of this, you have to do things electronically, started coming up. Before this, the Singletons nor my parents had any issue, or the Harrises had any issue with payments. And it, wasn't until all of this stuff started. And I just think that, Your Honor, it's stressful. It's caused people, frustration. And I, think that it's, you're asking people to pay, but you're frustrating the process of them being able to pay. And, Your Honor, I don't think that that's right. I think that, basically is just a travesty that this is, that this is even happening. And just lastly, Your Honor, and I'll probably stop talking, is that their own lease provides that, and granted, Your Honor, this lease is not one that we signed. This is what I received back in May when we kind of, I thought, had an agreement. But this is what we were provided, and the lease that the Singletons and the Harrises were provided state that they can pay at the community office, that they can mail it in, but they've since said that that can't happen. So that is in their lease, and it also indicates in their lease that if there's any statutory provisions that the lease violates or is in conflict with it, that would make those provisions of the lease null and void. But from what I can see, that the lease is not in violation, because it does provide for payments in person or through the mail. So Your Honor, that's where I'm at, and I can expound more on anything that you need.
Before Mr. Marks responds, my question was specifically about the lease, because you attached to your motion and attached to your answers, or your answers in both of these files. In the Harris file, you attached a lease that indicates that it starts April 1st, but it's not signed. I don't have a complete copy of the lease for the Harris file in either file. So I don't know that there's a signed lease for the Harrises right now. So the question was that lease from April 1st ever signed?
No, it wasn't, Your Honor.
Okay.
Yeah.
And then in the Singleton file, there's 2 pages of a 14-page lease that appears to be signed on May 11th of 2022 by Carl Singleton.
Yep. So they signed it. They signed that copy when we were in there. And what happened, Your Honor, is that I sent a letter to their registered office in Michigan because nobody could get a hold of anybody. So I sent a registered letter. I spoke with Ms. Sherman, one of their attorneys in another state. And she said that we could sit down, we would be able to look at the paper leases. And basically the agreement was for the Singletons as well as Mr. and Mrs. Harris, was that we would look at the paper leases, whatever changes needed to be done, they would do the changes. They were supposed to send me the documents because as I explained to them, they don't really know what to do with that. And so I was gonna, with their permission, was gonna look over the lease and then I would DocuSign it. So what happened is when we went in there, we looked over the lease, they did sign it, but there were changes that needed to be made. And they were supposed to, make these changes and forward it to us. And that never happened.
Thank you. Mr. Marks?
With respect, Your Honor, that is way beyond the scope of this motion. At this time, I have not had a chance to fully discuss that with my client or brief that. This motion, and with all due respect, Ms. Lacy's motion, which I'm presuming is going to be heard after this one, these are the exact same motion with exact same facts pleaded, with exact same exhibits attached, representing that they are seeking, the words aren't used in the motion, injunctive relief on behalf of all residents of the park. This is a completely frivolous motion. And I am at the outset, I would be seeking costs and attorney's fees for the amount of time and effort that I had in having to work with my client in order to come up with proper and legalistic responses to this. Initially, I guess we can talk about the e-sign act. And Your Honor, I won't go on and on. If you've read my response, I can touch briefly on the highlighted points because I don't want to waste the court's time. But the e-sign act is very clear that it says specifically that there needs to be a statute, regulation, or other rule of law that requires a business entity to provide individuals with paper or written communications before you get to the idea of the notion of consent. This motion fails to provide what statute, rule, regulation, law requires my client to do so. Secondly, this is an interaction, a business transaction between an entity located in the state of Michigan, city of Belleville, and residents of the city of Belleville in the state of Michigan. This is purely an intrastate transaction, not within the bounds of the e-sign act. Thirdly, Ms. Harris jumped around in places, but I don't see anywhere where the e-sign act talks about payments and methodologies of payments and how payments are made. Maybe Ms. Harris and her clients feel things are unfair and things like that, and I'm sorry that she feels that way. But unfairness is not anywhere near what we're talking about with the e-sign act. And thirdly, and the fourth point, I guess, is the e-sign act's intention was to streamline electronic transactions through interstate commerce. Now, presumably, this motion is a motion for injunctive relief. It certainly isn't crafted that way, but that's how I interpreted it after reading it and seeking and what they're seeking for relief from this court. There isn't a private cause of action statute within the e-sign act, and it should therefore be dismissed outright. The same applies for the Michigan Uniform Electronic Transactions Act. As I indicated in my motion, in order for any of the sections from my reading to come into effect, there needs to be consent on both parties to enter into electronic transactions. And as Ms. Harris's clients allege, they have never consented to it. The MUETA should be dismissed outright. Again, there is no private cause of action within that as well. I'm trying to understand exactly how this motion is crafted, but from what I gather, there evidently was some kind of communication. There's no documentation of it or anything about the FHA and the Persons with Disabilities and Civil Rights Act. And it looks like the motion is arguing that the elderly status of Ms. Harris's clients and their socioeconomic status requires my client to provide things to provide documentation in paper format. I don't know where that comes from. Those are not protected statuses within either of the statutes. That should be dismissed outright. And again, we're talking about injunctive relief. There isn't any arguments about the four-pronged test that I provided in my motion. Your Honor, I don't know really what else to say other than that. Again, Ms. Harris is asking this court to issue injunctive relief, not on behalf of just her clients, but on behalf of Park Estates. She has filed appearances and answers and counterclaims on behalf of the Singletons and the Harrises. And it looks like every single one of her requests for relief go outside the bounds of the Harrises and the Singletons, and asking for injunctive relief for all individuals, or in her opinion, conveniencing all individuals at Park Estates. Your Honor, I believe I touched on all the points. I'd be happy to take any questions that you have at this point, but I don't like doing this very much, but I'm bound to ask for attorney fees and costs and having to respond to this motion.
And Your Honor, I
Anything else,
don't.
Ms. Harris?
Yeah, I would just like to respond briefly, Your Honor. I was not saying that that the Harrises or the Singletons were a protected class. I was actually, in fact, saying that those acts that was referred to, and it was not Mr. Marks that told me that. So, but it was someone at his firm, and when we were talking, and that's why I put that in there, Your Honor. So I just want to be clear that I was not saying that this goes under the Fair Housing Act or that this it goes under the Persons with Disabilities Act, but I was told that they could request a reasonable accommodation, and I was saying that that was under the Persons with Disabilities Act and didn't apply. And then as far as the fair housing, it doesn't speak to anything as far as electronic transactions. So that was just the point that I was making, Your Honor, with regards to that. As far as the injunctive relief, Your Honor, I mean, it is, it is a relief in equity, but Your Honor, it has caused a lot of problems. And that's one of the reasons why there's so many of these cases on the court's docket. It wasn't until, his clients took over and all of this, stuff started happening. And I don't, and I think that one of the things that the Michigan Uniform Electronic Transactions is clear is that the parties have to agree, Your Honor. And I'm saying here, the parties are not agreeing. And then they're on top of that, if they're not agreeing, then, what is the remedy? If they, if you want them to sign a lease, why can't they have a paper lease? Give them a paper lease. Why do they have to be subjected to doing it electronically? And his argument is that, well, there's nothing that says that we can't do it. I mean, that's just to me not an acceptable business practice. There's every other business industry you have to, have this. And the problem is that, especially with the Harrises and the Singletons, there are some issues as far as, being able to view this stuff. Like I said, Ms. Singleton doesn't have a computer, so she can't review something. And something as important as a lease that binds you, that's legally binding, is something that somebody should be able to read. It should be printed out. They should be able to read it. They should be able to see it, have a copy for their records. Can't do that on a simple mobile phone like what she has. She has it's a smartphone, Your Honor, but it's it's not an up-to-date computer smartphone. So, and, Your Honor, if you decide not to extend it to the other Park Estates residents, that's fine. But as far as the Dropbox, Your Honor, I just don't even understand why that is not able to be instituted. It's there, they've taped it up, it's inside the building. There's just, to me, no reason for, this unfairness. And then it's causing a problem, and this is why we're even in court. The Harrises and Singletons are even in court, and this is causing undue stress. I mean, it's very stressful to be, facing the court with eviction and, everything. And Your Honor, honestly, if it wasn't, if it wasn't for the fact that they knew me, they probably would be evicted right now, because they came, basically they came in, made these representations that these people weren't paying, that, they weren't, doing what they were supposed to do. And I mean, honestly, I believe that they would have, at this point been evicted, and they had been paying through the pay lease that clearly wasn't working. So, Your Honor, I think that the Uniform Electronic Act of Michigan does apply. There's no exception given for landlord tenants. The only exceptions that I saw was just if there's something about wills or there's any other type of laws that, specifically deal with this issue.
Mr. Marks, I wasn't dismissing you. I saw that you had your hand up, and I was going to come back to you because I figured you wanted to respond.
I'm sorry. Yeah, I didn't mean to.
No, you're fine. Please do.
Yeah, again, Your Honor, I have to reinforce this point with the court's permission. Again, Ms. Harris failed to provide what law, statute, rule, or regulation obliges my client to act in a specific manner. Ms. Harris and her clients might feel as though that it's a proper business practice to do X, Y, and Z. That's fine. But that's completely different from the case at hand. Again, where in the Michigan Uniform Electronic Transactions Act requires my client to provide documents in paper form? It's not there. I read it many times. I've learned a lot about electronic communications and transactions in preparation for this motion. I've read.
Mr. Marks, I'm going to interrupt you because I see this as a two-part thing. The motion is written to stop the plaintiff from forcing residents to conduct business electronically. That's how it's captioned. So it's two things. It's don't make me sign an electronic lease and don't make me pay electronically, correct? That's the 2 points, right?
That's what I can gather,
Okay.
and that's
So-
how I summarize it. Yes, Your Honor.
There are parts of the community that I serve that have horrible connectivity. So the possibility of somebody A, having internet, or B, having a computer in the house and being able to access a lease electronically, some places just can't do it. Does your client have if a person doesn't have a computer, doesn't have an email address, is there a provision, is there a way, is there a regulation, a community regulation that would allow them to get a paper lease, either in the mail or in the office by appointment or something like that?
I would have to ask, and I don't want to put her on the spot because I'm not sure if Andrew, my client from is here in the Zoom. If there's an answer to that question, Your
Okay.
Honor, that's beyond the scope of what this specific motion is about. So I certainly
Mr. Marks,
brief it.
I'm asking because there are 11 of these cases in the hopper, and it seems like an easy enough fix with attorneys who have the experience that you all have. I'm not suggesting your client do anything extra. I'm just curious what would happen if we have people who just don't have computers. And so they drive here and they either come in the courtroom with me or they sit down in our Zoom room, which is an aside more than anything else. The second issue is the payment issue. I'm looking at a lease that says that and since nobody provided a full copy of the lease, I don't know what the lease says about modifications to the existing lease. The lease that says that you can come pay in the office or in the Dropbox. And then there's some letter in June that says, nope, you can't do that anymore, no exceptions. But what does the lease say about modifying the relationship between the parties? So for purposes of today's hearing, Mr. Marks, the court agrees with you 100% that the e-sign and the MUETA require your client to get the consent to conduct business electronically, except if there's already an existing lease that requires the parties to act with each other a certain way. So the issues are muddled because of how the motions are combined and the facts aren't specific, the allegations aren't specific to a particular tenant. And this court would not enter an order that said that your client must do these things with all tenants. And that's why I ask, is there a relief valve for people who are unable to access electronically? Like the singletons, which is the statement that Ms. Harris made.
I will have to ask if Andrea, if you're willing to speak to that at this point. I don't know off the top of my I have not been given it. This could get into ideas of ways of settlement negotiations, Your Honor, which I will certainly not put on the record. So I don't have an answer to that question at this point. Andrea, if you'd like to speak to that, if not, I'm sorry, I just don't have an answer right now.
I can't speak to that either.
No,
That's
ma'am.
different.
No. Turn your video on and identify yourself, please. Sorry, Mr. Marks. Sorry, Ms. Sherman. I didn't want to cut you off, but the video wouldn't pick up who you were and what you were talking about.
So I'm Andrea Sherman. I'm with Vineyards Management Group, which manages Park Estates. I'm not able to answer as to the different methods. That's a different department than I work in. So I don't want to speak to that without talking to someone that does the leasing.
Thank you. So for purposes of this morning, the court will deny the motion as relates to the electronic execution of leases, because the attachments in the files, there is a lease from the Harrises. Well, that you have, so it suggests to me there's a paper copy somewhere, and then there's a signed lease from the Singletons. So as for purposes of leases, doesn't really seem to be an appropriate argument to force them to produce a paper lease where you already have leases. As for the,
I'm sorry, Your Honor.
no, I'm stopping so you can finish, please.
Oh, I was just gonna say, Your Honor, that we do have, they did print us out paper leases, but they didn't want to, the reason why those aren't really like signed, although Ms. Singleton and them did sign it, and it's not really on file, is because there were supposed to be changes and they won't accept it unless it's DocuSign. So they're not even looking at this, the paper lease that is there, as even having a lease, because
are you
it wasn't
speaking, I'm
DocuSign.
sorry, are you speaking just as to the Harrises?
As to both the Singletons and the Harrises. So because
I'm sorry, so the May 2022 signed lease from the Singletons is not a lease?
not according to Vineyards, because it wasn't DocuSigned, it wasn't done electronically. I just put it in there, Your Honor, so that you could see that their lease that they did provide us shows that they say that you can pay at the community or pay by mail. And that's the only reason I put it in there.
Then Ms. Harris, we're back at the same spot. Nobody has provided the lease. Neither the defendants nor the plaintiffs have provided the lease. Whatever the last lease in effect is, you allow it to run out, then you're just month to month. You're bound by the same terms and conditions, and nobody has provided it.
And I can provide the whole copy of what we have, Your Honor, but only thing I can tell you is that because they didn't DocuSign it, they didn't do it electronically, they're saying that it's not valid. They're still counting them as month to month, I guess, they're charging them a month to month fee, and they're saying that this lease is not valid because they want it on DocuSign. They want it electronically.
In reading the e-sign act, the court just still agrees with Mr. Marks that it does not apply in a situation, and neither does the Michigan law in this court's opinion. And I do believe that they can require electronic signing. There is, and that's why I asked, is there a mechanism around it? And Mr. Marks doesn't know, his client doesn't know, although I don't know that I forecasted that would be a question before, because I didn't know that was the issue, and we can take it up on November. Maybe there'll be an answer by November 30th when the parties appear again. As for Mr. Marks, were you starting to say something?
I just want to make sure that what Ms. Harris was saying is accurate, and ask my client to confirm that with the Singletons. I want to make sure that was our position as well, as to why there isn't a current lease with the Singletons.
That is correct. As the courtesy, we did allow them to come into the office. We provided the paper form, as Ms. Harris did request, and we said that it needed to be signed on DocuSign. So the lease was never countersigned. I'm not sure when the Singletons signed their version, but it was not the official version to be signed. They just signed the courtesy copy.
Thank you.
Right. And they were supposed to be the changes when we read it over. There were supposed to be changes that were to be made or be corrected. They were supposed to send the DocuSign to me, and that never happened. And I did follow up with them, and I got no answer. So, Your Honor, I apologize if the motion seems muddy. I'm just saying I don't understand how they can just force people that don't have the means to sign stuff electronically. They don't have anything in the office. They don't have a computer. They don't have anything for people that may not have great internet. And, you know, that's all I was saying. And then on top of that, they're charging them all these fees saying that they, you know, don't have an appropriate lease. So, you know,
Ms. Harris, no, don't apologize. And if you heard, I agree with you in part, and that's why I asked Mr. Marks and I asked Ms. Sherman, and they don't have a response at this second. But this is a two-part thing for me. This is the lease, which I've now addressed, I think. And then the second part is payment. If you're charging people additional monies for not signing a lease for people you know don't have a means to sign a lease, that's another argument for another day. Understood? I mean, I hear what you're saying, and I agree with you to a certain extent, but they're just, if somebody said to you, I need you to go DocuSign this document and I'll give you $5,000, you find a way to get it done, or you find a way around it, or you find a way to be in communication. I'll stop talking because that's beyond the scope of the argument, and Mr. Marks is looking. The point is, the motion's denied.
Not looking anyway. I'm just analyzing what I'm hearing. That's all. That's how I look sometimes. I'm sorry.
It doesn't have to be as difficult as I think it's become. And I understand because of COVID, it's people have been reluctant to have more people in the office than they need to, but there's got to be a way to execute documents electronically for people who don't have access in their own personal units to computers or printers or the ability to sign. There has to be some way, some exceptions. And I know that when you're talking about somebody who's not stationed in Van Buren Township, which is where the park is, they might not have that same sense of connection to the tenants as other people, but there's got to be some way, there's got to be some accommodation, not fair housing accommodation, but some accommodation for the people in the park who. As for the payment, the electronic payments, there had been an argument previously that the vendor where you went to make the payments, Vineyards wasn't set up to receive the payments, or there was some issue with the transmission of the payment from the tenant to the park. Am I capturing your argument correctly, Ms. Harris?
I believe so, Your Honor. I was just saying that people, I mean, just in general, people have been having issues with the portal. And I know that was the same thing with Ms. Harris, the Harrises and the Singletons. And they did do the pay lease, but there's payments out there that have never been returned. They're floating around, and basically they have to figure out where these payments are. I did bring this to their attention before court action started, but court action started. And everything was fine when they were able to go to take the money order and drop it into the, give it to the community manager or drop it in the Dropbox. So now that's taken away, and they're insisting that it's done electronically. And I'm just saying, that's not working clearly. And it just is creating a hardship, for people to pay. And it has just really frustrated the process. So they are required to pay, but they're frustrating the process to pay.
Your Honor, perhaps this, no? You want me?
No, I'm listening to you. I'm shaking my head about something else.
You're shaking. Sorry. Perhaps this might be a issue of partial payment, where Park Estates is not accepting partial payments. That's somewhat speculation because I'm not entirely sure as to the specifics of what payments Ms. Harris is speaking of, but that might be part of what we're talking about here, is that some payments might have been made through the pay lease program that didn't zero out the balance and were subsequently not accepted. That might be it. I'm not entirely sure, but that might be where we're headed. But I guess I would reiterate my point is with as far as payments goes, that this motion, again, going back to the motion instead of a more global universal idea of what's going on here, the motion does not indicate where my client is required to accept payments in specific manners.
But Mr. Marks, and that's why I'm shaking my head, because I am stuck on the fact that there is no complete copy of the lease, whichever lease is currently binding on the parties. If I have a lease, even if it's from 2018, that says that tenants may pay in person, and then a later provision that the only way to modify the lease is in signing countersigned by the other party. then I don't know that that June 2022 letter can change the terms of the lease. So that's speaking to the argument about requiring the tenants to conduct the payment business electronically, which I see is slightly different than the signing of the electronic lease, if that makes sense to you.
I understand. Your
Okay.
Honor, but I don't know. I'd have to reread the motion. That certainly wasn't the crux of the motion. The crux of the motion was, it was from what I was reading and what I was deducing was that my client should be obliged to conduct transactions in paper form due to the particular circumstances of Ms. Harris's clients, and through the legal obligations of the e-sign Act, MUETA, FHA, and the PWD-CRA, which I won't keep on messing up. But that's how I briefed it, because that's how I read the motion. But I'd certainly defer to the court if you have further questions.
The motion specifically says that beginning in January, the residents were advised they wouldn't get hard copies of their monthly statements, were only offered online options to pay. And that's why I said originally that I see this as two different things: making people sign a lease electronically, which you only do once a year, and requiring people to pay online electronically. So the court's position remains the same, that the e-sign Act does not apply, and neither does the Michigan equivalency to force to prohibit your client from requiring docu-signing of the lease. So that's the one part. The second part, offering only online payments. The parties are bound by their contract. And if the contract is what it is regarding how payments are to be made, then the court would grant the motion, but neither party provided the information that the court needs to make the determination that that paragraph regarding how payments could be made could be changed with just a simple flyer. So if somebody's willing to provide a full copy of the current enforceable lease in each of these cases, the 2 right now and then the 5 that are coming up next, then a ruling could be made. But for right now, I don't know that either the defense motion or the plaintiff's response specifically address the simple issue of the contracts case, which is what this is, the modification of the contract regarding the payments. I'm not thinking the global part of it, Mr. Barks. When I read these files, I'm looking specifically at what lease is in effect. And when I see that Mr. Harris's lease is attached to multiple motions that aren't relevant to his tenancy, it's made it difficult to kind of work through the specific narrowing of the issue so we can get back to what these are essentially, which is just non-payment summary proceeding cases. These don't need to be what they've become.
And Your Honor, I apologize. I do have like the entire copies of what they gave me, what they gave me at that time. But I can give you what I have there, and then I can ask them for their previous lease, because actually I guess that's probably what they'd be going under, since they're not really accepting, they're just doing month to month.
Andrew, do you have the old leases?
I'm
sorry, I didn't mean to interrupt you, Your Honor.
No, please, sir.
I was just going to ask if Andrea has those old leases. It was under a different management, so I don't know.
Sorry, I keep turning off my camera for all of you. I'm sick, so I don't want to cough on the camera for you first. But as far as the old leases, I don't think we have them. They were under the old management company. I just tried looking, and I'm not.
They actually do have them, because I saw them when I went in there in May. So they have them in the office.
Okay. I can look into that. As far as what I have online, I don't have a copy of it that I can pull right now, but I'll check with the staff there at the office.
So the defense motion in these matters, defense counter plaintiff's motion, is denied in part as relates to the electronic signing of the lease. The court's reserving ruling on the forcing the electronic payments, because it's not clear. It's not clear if not because of the statute cited by the defendants, but because of the contract that binds the parties that would bring us here on the summary proceeding. Ms. Harris and Mr. Marks, I don't know how else to move us forward in these two cases regarding resolving the issue of the payments. If Ms. Sherman is able to have somebody look and see what the most recent binding lease is, we're bound by the terms of that lease, specifically with the provision regarding the modification of that lease. But that's not to affect how Vineyards conducts its business on a larger scale. It's just specifically to these tenants and what the terms of their specific leases provide. If that makes sense to you, Ms. Harris and Mr. Marks.
Yeah, I understand, Your Honor.
I'm not saying it probably as eloquently as I could, but these cases are awfully thick for what should be summary proceedings and the issues that we haven't, the true issue at hand that we haven't even started to discuss, which maybe we'll take up on November 30th.
Your Honor, piggybacking off of that last comment, that these are much simpler than what is had, and the fact that we're having this hearing today on this specific motion, when the crux of this motion is now being held on is not what was the crux of this particular motion. I would be seeking attorney's fees and costs and having to defend it.
How do you not see this as the same as the
Because again, Your Honor, because there was no, it might have been briefly mentioned, I'd have to again look, but the crux of this argument again was obliging my client to act in a specific manner based on these electronic transaction acts, both federal and state. This was not a motion to enforce a contractual obligation. This was a motion to stop plaintiff from forcing residents to conduct business electronically based on these specific statutes. And again, I don't mean to belabor the point, but I feel I totally understand what you're saying. And, you know, I'll talk to Andrea after the hearing and hopefully we can get those documents for you. But I feel as though we're arriving somewhere that wasn't really aimed at according to.
I'm sorry, you said we've arrived at somewhere that wasn't aimed at?
Yeah. We're I'm sorry.
I said, oh.
And it's fine. This motion could have been injunctive relief to enforce the latest contractual obligation. And that's certainly not what this was. And if you deny me, that's, you know, I certainly defer to the court, I respect the court and understand it, but I'm duty bound to at least ask for that because I feel as though I briefed things that really weren't relevant to this case, and to be honest with you, somewhat frivolous.
Yeah, I just don't feel that was frivolous at all. I really just wanted to, you know, if Your Honor is saying that these acts don't apply here, you know, that's fine. But Your Honor, I mean, I feel like the defendants had a position, the plaintiffs had a position. We did ask the court for guidance, and I just don't see where it was a frivolous motion because, you know, Your Honor, this is the crux of the whole issue as to even why the Harrises and the Singletons are even on your docket. And so, you know, that was my thing. So I wasn't trying to waste the court's time, Your Honor, and I wasn't trying to, you know, waste Mr. Marks' time. And, you know, clearly some of the things he misread, and, you know, that's why there was, you know, he briefed, I guess, some of the things the way he did, but.
Ms. Harris, I don't take it as a waste of the court's time. This is a unique situation. And I know that we've had other Park Estate cases that had these same starting issues that had managed to resolve themselves. And maybe based on some of what's happened today, these cases continue to move through differently. This is probably the fourth time that we've been here on these types of issues, not this specific case. We'll be back on November 30th, and there's some that are differently on a different track already. The court's denying the defendant's request, the plaintiff's request for cost at this time.
Thank you, Your Honor.
Mr. Marks, will your office submit orders in these matters?
I can. This is Ms. Harris's motion. I certainly can. You would like me to, I can craft a proposed order denying as to the execution of conducting. I just want to make sure.
I'll put it back on Ms. Harris. It was always my thought that the prevailing party provided the motion.
I can. I don't have to. I just want to make sure I get the verbiage correct. So, and also we're waiting on the payment portion too. So, so I guess a matter of how you would like me to craft it.
I don't know, Your Honor. I mean, I guess it's denying it as to the electronic lease, but it's reserved as to the payments until we get the leases.
That's how I see it, but I don't know that we really want to hold them open like that.
Should we do it on November 30th, Your Honor, when we will be able to provide the leases to the court?
I was thinking that, Mr. Marks. I hate to do that. How long do you know? Can you guess? You know what? No. November 30th is 2 weeks away. If your client is able to get someone in the office, and if there are the most recent leases in the file, provide them to the court in their entirety, and I'll issue a ruling on the motions in their entirety at that time. Well, I hate to bifurcate. I'm just trying to think it through procedurally, since I know these other ones are out here.
Knowing how you're again, I'm not suggesting anything, Your Honor, but knowing how you're willing to proceed, I'd be okay with once my client makes a determination as to where those are, if they're obtainable, and sending them, deferring to the court as to an order that is perfectly fine for our purposes. But however I understand you have procedural ways that you have to do things, but that would be fine from our perspective and on our end.
To deny the electronic signing at this point and hold the matter of the payments in abeyance?
Or just hold the entire thing until we send the document, then you issue an order.
Let's hold them in abeyance. I'm just trying to think, Mr. Marks, because I know that Thanksgiving is coming too, and if your client can get the leases, the earliest we could possibly get them would maybe be a week from now, 2 weeks from now.
If I'm correct too, the 30th is not the jury trial. That's just an updated hearing as to where we are, right?
Those are just pre-trial dates, correct?
Right,
We'll
so,
schedule the jury trial date on that day. So let's do this. Do an order that denies the motions as relates to the electronic signing of the lease, and hold an abeyance ruling on the payments. I want to use the right. The payment portals or pay lease. And if you can get your client, if they send you the binding lease on the tenants before the November 30th date, just send it over. And I'll look at it, and I'll make a ruling at the during our pre-trials on November 30th.
I will submit this under the 7-day rule, Your Honor, and Tabitha, if you have any qualms with how I verbalize it, I'd be happy to change. I will do, yeah.
Okay.
I will certainly, yeah, I will draft something. I'll email it to you, Tabitha, and also serve it on all the parties, and then, hopefully I verbalized it properly. So
I'll send the files down to civil, but then I'll bring them back up here in case the lease shows up, so that we can. I'm talking more to Mary Ann, but thank you, Mr. Marks. Thank you, Ms. Harris. Anything else, Ms. Harris, this morning?
No, that's it, Your Honor. Thank you.
Thank you, ma'am. I'll see you on the 30th.
Yes, ma'am.
These are these are Park Estates versus 223385 LT, Carrie Taylor, 223374 LT, Susan Gunderson, 223381, Philip Roy, 223387, Tessa Thompson, 223384, Rudy Smith.
Thank you, Gabriel Lacey.
Appearances.
Larry, I'm sorry, Your Honor. Gabriel Lacey on behalf of the Taylor, Gunderson, Roy Thomas, and Smiths.
Thank you.
Pete 79685.
Jeremy Marks appearing on behalf of plaintiffs. And Your Honor, just before we begin, I want to let your clerk know that I've had requests to let people into the Zoom session, and I just want to make sure that everyone's in there. I actually let Ms. Lacey in, and because I think I was named as a co-host, so but I'm not currently doing that because I'm in hearing.
I don't know people home because I'm looking and I don't have anybody waiting.
Okay, good. Okay. I saw someone waiting and I was arguing, so I didn't click them in. So I just want to make sure that everyone's good at this point. So thank you.
I think it's my 1030 case, maybe.
I just want to make
Ms.
sure that no
Lacey,
one
you've
was
been
not
here
letting
for
that
the
be
bulk of the arguments.
Correct, Your
regarding
Honor.
the-
And I actually was going to say I'll stand by Ms. Harris's argument. I did hear your reasoning and I heard Mr. Marks' reasoning. I was paying attention to the whole thing, and I will accept the ruling that you gave to Ms. Harris and the position that the court has taken,
Thank you.
just to save
Only,
time.
no, save time. The
It would
only
really be
case that
redundant.
Didn't seem at issue was the 3381 case that was dismissed previously. That was dismissed back on October the 19th, Park Estates versus Philip Roy.
Yeah, and you know what, Your Honor, I'm doing these pro bono, and I just I got notification that that one was taken care of, and I forgot to take it off of my list, so I do apologize.
That's no worries, ma'am. The court's ruling will be consistent with the prior cases that the motion is denied as to the electronic signing of the leases. But in these cases, there's not even a page for any of these tenants and what terms of electronic payment would be allowable.
And I will have,
And I think that I'm sorry.
I was going to say, I will have my clients get their last standing lease, the last valid lease that they have, and provide that to the court.
Thank you.
Your Honor,
Mr. Marks, my issue is specifically what the lease modification provision is.
I understand. Yeah.
Okay.
But procedurally, Your Honor, if I may, none of these defendants have filed answers in these cases. I have an appearance by Ms. Lacey, and Ms. Lacey, if you have filed answers in these cases, I'd be happy to review them. I did not receive anything, and if you did receive them, I apologize, but I have not received them. I think the rulings even on this motion is not the proper procedural manner in this fashion at this point. Now, it's, if anything, they're in default for appearances being filed, but no answers being filed even remotely close to when those appearances were filed. So I'm not even entirely sure that the individual cases that are not dismissed, I thought there was another one too.
There is an answer filed for Gunderson.
Do you mind sending me that, Ms.
They
Lacey?
filed that pro per, actually.
I don't know if that ever got to the file.
Okay.
I'm sorry, Mr. Marks, I guess because your office appeared on October the 19th and agreed to adjourn the hearings in these matters to November 30th. If there was some acquiescence to Ms. Lacey's appearance, I'm just addressing your argument regarding the request for default.
Certainly an acquiescence to her appearance. Like that goes without saying.
And if I if I may, Your Honor, we've actually had some progress in the reason why we moved it to the 30th. You know, Ms. Harrison, I have been in the office with their representative. We've been given letters. We're currently going through those now. And we've set up or are setting up the escrows with the court. I have money orders to be dropped off today. So we are moving towards, at least in my cases, some of the resolutions. But I did file answers, and I will make sure the court has them and Mr. Marks has them by end of day today.
Mr. Marks, you were starting to say, and I thought that the indication was that the motions were not proper because there had not been answers. Is that where you were going?
Yeah, I feel as though maybe I'm wrong, but procedurally, I feel as though that, well, I mean, if this it's changed now, if Miss Lacy has now said that their answers haven't been filed, I just don't have them. I you know, and if they've been filed, then I certainly, you know, I retract what I said. But I feel as though that we're in motion practice prior to even you know, answer, you know, like again, like before this conversation happened, before even answers were filed, and for Miss Lacy's clients as to what you know, what they're you know, what they're claiming, other than just using the motion that was filed by Miss Harris, again, verbatim.
So would you rather us adjourn this motion to the November 30th until you receive the answers in the 3 remaining files? Because once, well, I don't know if an answer will be filed in the case that was stayed for the Sarah funding.
I guess we'll just go, you know, now that Ms. Lacy said answers were filed, we'll just proceed with it. You know, that information came to light after I initially brought up the issue. So.
And, you know, I'll double check. I know for sure I filed Gunderson filed Procure. I will double check the other ones. You know, I'm a single person office, so I may have them sitting in the draft box to be filed, but and I do apologize if that's the case, but I will double check today.
I would move for default for if answers are not filed. I would move for default in those circumstances. I don't have because there's 5 different individuals. From what I understand, we're not proceeding with Mr. Philip Roy. I understand that, but I would be seeking defaults on the ones that are not filed.
And I'd be objecting to those because we are currently in negotiation. When I was here last time, we did agree to the November 30th date so that we could negotiate the terms of the complaints from the plaintiff, and we've been making some progress. So I'm going to object to the default. And I do believe that answers were filed. I'm just not perfect.
There's an answer in Rudy Smith. There's an answer in the Gunderson file, in the Thompson file. That case was stayed for Sarah back on September the 14th. And in the Taylor file, there was Ingram who appeared for plaintiff's office and agreed to adjourn the matter till November 30th at 10:30 a.m. So the court's going to deny the request for entry of default judgment based on the ROAs that show either answers filed or agreement by the parties to adjourn these matters. And
Thank
Mr. Marks, if you're asking to hold the motion in abeyance, I'm happy to do that.
Not at this time, Your Honor.
Okay.
We can proceed like we did at the previous hearing now with that information. Ms. Lacy, I would just ask you to provide those answers to me. You can email them to me. I'd very much appreciate it. Thank you.
Okay, I will.
Then we will do that. The ruling will be the same, that the request to stop plaintiff from the docu-signing or electric signing of the lease is denied in its entirety. The ruling on the payments are held in abeyance pending receipt of the lease that shows how to modify the terms of the lease.
Thank you, Your Honor.
Anything else, Ms. Lacy?
Nothing further at this time, Your Honor.
Anything else, Mr. Marks?
Nothing, Your Honor. I will circulate those. I will obviously serve and circulate those 7-day orders.
Thank you so very
Hopefully
much,
today.
sir. I will see everybody on the 30th. Thank you.
Thank you very
Thank
much.
you, Your Honor.
This is 220223LT. This is Walter Sikowski as the representative of the state of Tana Rouse Hartwell versus all occupants at 49066 Tagauti Pass in Van Buren Township. May I have your appearances, please?
Tiara Brewington.
And I know that Mr. Horka is here. He's possibly in another courtroom, but he is still logged on with this court.
And Judge, my brother could not today. He has been admitted to St. Joe.
How is he?
He had problems with his heart. He fell out a couple months back, and he was admitted days ago. He was having issues with his heart. It took him in.
I'm sorry to hear that development. I know that he'd had some medical issues before, so I will send your family wishes for his full and speedy recovery.
Thank you.
Mr. Horka? If you're on with another court, just let me know and I'll let you go back to what you're doing.
I'm ready, Your Honor. Thank you so much for your patience.
No, thank you for your patience. This is the day and time set for hearing on plaintiff's request for entry of an order of eviction. And this court did receive from the defendants a response to that motion. Mr. Horka, did you receive? It's in letter form, received yesterday, actually.
As of yesterday's mail, I've not received any correspondence from the defendant.
Okay.
I haven't gotten it yet, but I sent it over yet.
Mr. Horka, the letter goes to the probate case that has been pending, and I know that Mr. Stanford brought it up previously, and the court's question had been all along, should the probate proceedings stay any additional action in this court?
And it's my understanding the defendant's prior actions in the probate court were to remove Mr. Sikowski as the personal representative. According to my client, those efforts were futile and he remains the personal representative. I am not aware of any other pending stay or action in the probate court that would prohibit this from going forward today.
Yes, Mr. Horka, we went back to court after that for the exclusion of the, you probably weren't there. And we appealed it and we are awaiting a court date. That went in on August 3rd.
So again, at this time, there's been no stay. My client remains the personal representative. I don't know if her appeal will be successful, but at this point, I'm asking the court to grant possession of the property. Court previously granted possession, given the facts that were presented to it. We're simply here on a writ hearing today because we're beyond 56 days of entry of judgment.
Yeah, I understand, but that was prior to the court date that we had before the judge. So, and that was prior to the evidence that has been sent in, which was accepted for a court date based on the information that I sent to exclude the husband. I'm sorry you weren't, you didn't know, you weren't at that court date. This is the only court date that you come to. So you probably haven't spoken to Walter about it yet.
Mr. Horka, was there something else?
Judge, I would just indicate that there was no appeal of your decision here at the district court level. So your prior order granting possession of my client remains in full force and effect. If she would have appealed that decision, then she would have to place a bond, be paying escrow, protections for my client that if there was a delay related to this case, that at least they'd be protected. That hasn't been done. So at this point, the only thing before is my client needs permission pursuant to the court rules, and I'm asking for that here today.
And Your Honor, I'm saying today, based on things because things have changed since then, and I am asking for that default to be, taken back and for a review on this case once that appeal is pushed through, because this could, give more harm than anything if we don't handle this delicately. I know they want to move forward and things like that, but he's not even up to date on what's going on currently. So
He's not even up to date on what, ma'am?
he had no idea about the last court date that we had, the rescheduling that we're doing in regards to the husband that was accepted. So he's not even on the same page. He has no idea what has since the last court date that we had before you. So yeah, things have changed. My appeal was accepted. So they are going over that evidence in regards to the husband. And if he is excluded, the property will go back to my brother and I, as we have already taken care of the lien. And at that point, Medicaid is taking payments from us. So at that point, that would have to close the probate estate case. So I think it's definitely worth waiting to see what happens at this appeal. Because if he is excluded, and I've given that evidence, same thing I gave to you, I gave to them, the courts are well aware about it, and that's why they accepted it. So with evidence like that, it is, something to consider before, just trying to throw us out to save face.
Not about saving face, Judge. This property has expenses that are incurring, and my client's receiving no rent. They're unable to sell the property with the defendants occupying it. Again, I know the record's clear, but I want to make it even more clear. Her appeal is to the denial of removal of personal representative. It was not to this case. So at this point, the defendant can't use this hearing to attack the underlying judgment. Underlying judgment is in full force and effect. Unless you have a court order in front of you from the probate court that stays this matter, this court has every reason and jurisdiction to proceed forward and grant the writ here today.
Yes, I do understand that as well. However, you keep mentioning the Walter. We're past that. We have 2 court dates since then. Representative, that's fine. We are way past that. We are not questioning him being representative. We have not appealed. That's right. You're not on the same page. We never appealed him. Once we had that court case, we never appealed. We are talking about the exclusion of the husband at this time.
Ms. Brewington, respectfully, what Mr. Horka is saying is that there had been a judgment entered in this matter back on April 4th, 2020. I'm sorry, on March 25th, 2022, which required that the occupants at the property vacate on or before. Sorry, let me go back to it.
Yes, ma'am, I'm well aware about that.
It's on or before April 4th, 2022. And this termination of tenancy was brought by Walter Sikowski as the personal representative of the estate. Even if the husband is excluded, the personal representative, whoever it is, acts in the interest of the estate. So unless there has been unless this court's March 25th judgment had been upset, this court is required to enter this order of eviction.
Yes, his interest of the estate was because of the lien that was on the property. And that's why it's so important that, and we were granted a waiver on that lien. And that was the interest of the case in the beginning. But we went to court on that already in regards to that payment. And I also included the exemption of that lien. So that was a priority when he put that motion in to evict us. Yes, ma'am. But we went to court on that. And the Attorney General signed off on the exemption of that waiver. I'm not denying that he did have an initial reason to move forward with that eviction. But as of today, the issues that were, that arose have been settled. So right now we are relying on just the husband and us at this point. And like I said, my appeal has been accepted, and I just think that a lot could go wrong. You know, it could do more harm if we just, like I said, this case was in the middle of COVID. They postponed it numerous times. It is not my fault that it has taken so long. I apologize. I've done everything that I could to get everything in a timely fashion. But there's been times where it was out of my control. They postponed it at least 4 times, at least. But I am asking this court to just, could you please allow the appeal to be, let us have our day in court.
Mr. Horka, the document that was submitted by Ms. Brewington asked for a 2-week adjournment based on some of the issues that have been occurring, and
At least so he could get on the same page.
Mr. Horka, I'm sure you have an objection to this, but the court will adjourn this matter very briefly. We'll put you on our November 30th
Okay,
docket at 10 a.m.
okay,
But Ms. Brewington, the court's inclination is to sign the writ on that day at that time.
okay.
Unless there is some order from a higher court directing otherwise. The fact that you and your brother and your mother's husband are in disagreement in probate court doesn't affect who has the right to direct this property at this time, unless there's some order that would have some bearing on this case. Right now, there is not, but because of your arguments and the fact that the probate case has been continuing.
Yes, ma'am.
Mr. Horka, I just want to err on the side of caution, because of the issues that have been raised, not just this morning, but previously in this case. Anything else on behalf of the state
No,
or the
ma'am.
representative?
I do object to the adjournment, Your Honor. If there are any further delays in this case, I will be seeking an escrow order if this matter continues.
An escrow order. Is there, who's paying for the maintenance of the house right now?
We are.
Okay. So the escrow order would be what, sir?
The estate has expenses. They have to pay attorneys, they have to pay the personal representative. They have to make an income to keep the estate funded. And they're deriving no income to my knowledge at this point.
Both have.
Ms. Brewington, no. When we're back here on November 30th, unless there's an order from the probate court, this court will be signing the order for eviction on that day.
Okay, thank you.
Thank you.
Thank you, Your Honor. Have a great day.
Thank you, Mr. Orker. You too.